Hi, Kelly from Kannen Mediation here. I just wanted to do a quick clip today to talk about Section 60I certificates. Most specifically, I've heard a lot of talk recently among other family dispute resolution practitioners about whether to issue a Section 60I certificate if Party B state that they're willing to mediate but they can't afford your services, so they're going to go through legal aid or someone similar. So here's how I do it at Kannen Mediation. When I finish my intake with Party A and I approach Party B and they say, no, I'm going to go through legal aid, I say that's fine, totally understandable. If you qualify for legal aid, that's a good avenue for you. I would ask that you let Party A know within 14 days that that process has commenced. And I explain to them that the reason for that is that if they don't start the process with legal aid, I will need to issue the Section 60I certificate to Party A. I then go back to Party A. I tell them that Party B has expressed that they can't afford private mediation services. They're going to go through legal aid or similar. And I let Party A know that they have a couple of options. I let them know that the potential is it'll be a longer waiting time if they go through one of those services, like Legal Aid or Relationships Australia. And I suggest to them that they contact Legal Aid and ask them what the current wait time is so that they know for themselves what they'll be waiting, how long they'll be waiting. And then the choices they have are they can either wait for that process to come about, or they can offer to pay Party B's mediation costs. So obviously if they are prepared to do that, I go back to Party B and I put that offer on the table for them and then take it from there. If Party A says, no, okay, I'll wait for the legal aid process, that's fine. I then advise them to let me know if they haven't heard anything within about 14 days, if they haven't heard anything, to contact me if they would like the Section 60I to be issued. Now, there's a couple of reasons why I've chosen to do it this way. The first one is if Party B want to take the time to go through the legal aid process, it's not really fair to them to issue Party A with the Section 60I without giving them the opportunity to pursue that avenue. But the second reason is it's not really very fair to Party A either, because if I charge Party A the $150 it's going to cost for the Section 60I certificate, and then a week later they get a letter from Legal Aid, or 2 weeks later they get a letter from Legal Aid, the certificate becomes redundant, right? Because they can't go to court with a Section 60I if Party B are in the process of organising mediation. They're willing to mediate. So I always tell Party A the reasoning behind this process, and I ask them to let me know if they haven't heard anything. We might do a follow-up email with Party B and say, have you commenced your legal aid application? If so, could you please provide evidence? Otherwise, I just go straight back to Party A with a Section 60I. So I hope that's been of some help to some of you. It's just another alternative. I'd love to hear if there's any other FDRPs out there that have different ways that they handle it. Please put it in the comments on this clip, or contact me. My contact details are on my website, www.kannenmediation.com.au. Thanks for your time. Bye.